I have carefully listened to the submissions of counsel for the applicant, advancing reasons why court should grant the application for a vote recount of the district woman representative to Parliament for Bukomansimbi district. I keenly listened to the submission of counsel Abert, who represented the Electoral Commission as the second respondent. I had ample time to go through the application from the time it was filed and have also gone through the reply and affidavit in rejoinder. According to the applicant's application, this application was filed seeking an order for a vote recount under the supervision of the Chief Magistrate for the post of District Woman Representative of Komansimbi District. The ground advanced in the application as a first ground is that the total number of votes polled by the applicant in the 217 polling station in Bukomansimbi district is 23,887 votes, yet the results read by the returning officer, Bukomansimbi district, indicated that the applicant had got 23,275. Those who studied mathematics, you can get the difference from what he thinks he polled according to DRA forms and what was pronounced by the returning officer. And the respondent had got 23,481 votes. According to the applicant, several of her votes at the polling stations clearly indicated what she availed as declaration of results form were not votes put in the tally sheet, which formed the basis of announcing the first respondent as a winner of the said Bukomansimbi woman representative to Parliament. During the hearing of this application, counsel for the applicant indicated that votes as is in the DRA forms for the applicant were either reduced or the first respondent was given more votes than what she actually polled at different polling stations in Bukomansimbi district that counsel Abert submitted all during the application. From the submission of counsel, the counsel for the applicant, votes for each candidate left the polling station intact, and the only issue is that they were tampered with at the tally center and on the tally sheet, where the respondent would be given more votes than those that exist on the DRA forms. It should be known that the declaration of result forms are source documents of a tally sheet, and therefore information on a tally sheet is expected to correspond to information on DRA forms if the process was chronologically genuine. In my view, the best way to provide a solution in the application before me is to compare the returning officer to add the votes as per DRA forms and to generate a tally sheet that corresponds with the DRA forms filled at different polling stations. I wish to clearly make it known to the parties that the role of this court in a vote recount as indicated in section 74 does not include such a jurisdiction. But such a jurisdiction is in the High Court, which has unlimited jurisdiction as opposed to Chief Magistrate's Court. Therefore, the proper way the election matter can properly come to High Court's attention is through filing an election petition, because this is where a court will get opportunity to evaluate the process of how the election was conducted. Therefore, considering the fact that the complainant or the applicant is not, considering the fact that the complaint is not on numerical figures on DRA forms, but on a tally sheet which is generated through adding the votes on DRA forms, I find that in this very application there is no need for a recount. The best remedy is to petition High Court for a prerogative orders, because if genuinely the DRA forms presented by the applicant are the ones with Electoral Commission the tally sheet presented to Electoral Commission, they should be reflected on the tally sheet. The applicant would be having a prima facie case. Therefore, I conclude by saying that this is not a proper case for a vote recount. As regards to non-inclusion of returning officer, though not fatal, the omission is not good practice, because it is common knowledge that while the returning officer is an employee of Electoral Commission, he or she is responsible for coordinating, conducting elections for district woman member of parliament, and thereafter declare the winner. Non-inclusion of the said returning officer of Komansimbi district is condemned because court cannot condemn him or her unheard. As regards to costs paid for, I decline awarding costs to any. Why? The dispute is not yet resolved, and besides, the proper person that should have been condemned would be the returning officer, if at all proof would have been made that he or she is responsible for all the mess. This is still work in progress. I advise the aggrieved party, i.e. the applicant, to file a petition in the High Court after gazetting the winner and quickly resolve the matter, and considering the fact that court was informed that the results have been transmitted to Electoral Commission, I recommend that Electoral Commission quickly gazettes the winner for Bukomansimbi woman member of parliament, to give room to the applicant to file a petition if interested. This will also save the people of Bukomansimbi from anxiety and tension of not having a settled mind on who the woman member of parliament is. In the nutshell, this application is dismissed.